Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishment. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, the class C misdemeanors are cases that start either in the city court or the JP court. They only come to this court when a person is convicted in the JP court or the city court and they appeal their case. In essence, they get a whole new trial in this court. Now, the range of punishment stays the same. The range of punishment is a fine. You cannot be given jail time. And the fine cannot exceed $500. Now, however, if you fail to pay the fine or if your fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. That simply means that the court can issue a warrant for your arrest for you to either pay the fine or for you to sit the fine out in jail. And if you sit the fine out in jail, you'll receive $100 credit for every 1 day that you served in jail. Now, the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a class A misdemeanor. And with the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the unadjudicated probation, which we call deferred probation, the case will be dismissed and you may qualify for what is called a non-disclosure. What a non-disclosure is basically means that your record is sealed to the general public. That is, the general public cannot have access to it. Now, most of the public is the general public. Now, the operative word that I use is general public. The government and certain governmental agencies that's listed in the Texas Code of Criminal Procedure can have access to it. But most of the public is the general public, so most of the public cannot have access to it, okay? Now, the next type of probation is called adjudicated probation. We normally refer to it as regular probation. It does result in a conviction on your record. However, there's something that is called judicial clemency. What that simply means is that the court or the judge can set your conviction aside, which means you will no longer have a conviction. Now, in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, the probation office has to successfully discharge you off of the probation. If those three things happen, then the court has the discretion to set your conviction aside, which means you will no longer have a conviction. Now, if you get another conviction later on, then the case that you received judicial clemency on can be resurrected, revived, brought back up, and it can be used against you. So if you try to get a license with Child Protective Services, which is CPS, bless you, then they can deny giving you the license, or they could, if you have a license, they could suspend or revoke that license. All right. Now, the paperwork that you have in your hand, and everyone here should have a clipboard. I'm going to go over that clipboard with you. Now, that first page, that's important because everybody's gonna sign that first page in one of three ways, and I'll explain it to you. The first page is titled Judge's Explanation of Rights to Defendants Without Attorney. Make sure everyone have that. In that document, it states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first paragraph below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court from today to give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or you may ask the court to appoint an attorney to represent you. But you must first sign or fill out a financial questionnaire. Now the financial questionnaire is a 3-page document that is also on the clipboard. That 3-page document is titled Jefferson County Affidavit of Indians. Now, you would have to fill out, now this is only for people who will be requesting a court-appointed attorney. So if you're not requesting a court-appointed attorney, you don't have to worry about that document. But for those of you who will be requesting a court-appointed attorney, you would have to fill out the first page of that document. And then on the second page, you would have to fill out the top portion that is titled Defendant's Oath, and the middle portion of the second page that is titled Unsworn Declaration by a Defendant, and then you'll stop. Okay, so let's go back to the first page, Jefferson, the Judge's Explanation of Rights to Defendants. Now, the third paragraph under number 3, this is for individuals who will be representing themselves. If you're representing yourself, you'll be acting as your own attorney. And because you're acting as your own attorney, you'll have an opportunity to talk to one of the assistant criminal district attorneys in court to see if y'all can work out something on your case. Now, that paragraph states that you may not speak to the prosecutor is the assistant criminal district attorney, unless you first sign a waiver of your right to be represented by an attorney. Now, the waiver, and this is only for people who will be representing themselves. If you don't want to represent yourself, you don't have to worry about what I'm getting ready to say. For those individuals who like to represent themselves, you will have to sign a document, another document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. You'd have to read that document and then sign and date it today's date, September 2nd, 2025. Now, the second to the last paragraph on that first page, on that first document, judge's explanation of rights of defendant without attorney, that it's in bold print, it's in block form. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, that last paragraph, that one sentence paragraph, basically states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, that first document, it states in bold print, defendant's choice, mark initials next to only one choice. Now, if your choice is to hire your own attorney, then you'll place your initials on the first line to the left. Okay? If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you would like to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you would place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, September 2nd of 2025. And so, as a brief recap, everyone is going to make a choice on this form. If you want to hire your own attorney, you'll place your initials on the first line to the left. If you would like to ask for a court-appointed attorney, you'll place your initials on the third line to the left. If you would like to represent yourself, that is, waive your right to an attorney and represent yourself, you'll place your initials on the fifth line to the left. Once you have finished initialing one of these lines, then you'll sign your name on the line that's titled defendant, and you will date it today's date, September 2nd of 2025. Okay? Now, for those individuals who will be requested a court-appointed attorney, who will be asking for time to hire their own attorney, this is the only form that you have to sign. This is it. Once you place your initials on the first line, sign and date it, you can stop. You don't have to worry about that other form. If you are requesting a court-appointed attorney, then you will place your initials on the third line to the left at the bottom, and then you will fill out this form that is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page, and then on the second page, you're going to fill out the top portion that is titled Defendant's Oath, and the middle portion that is titled Unsworn Declaration by Defendant, and then you'll stop. If you are waiving your right to an attorney, that is, you want to represent yourself, you place your initials on the bottom line, the fifth line of this first document. You will sign it and date it, today's date, and then you will go to the form that is titled Waiver of Counsel for purposes of entering a guilty plea, proceeding the trial. You would read, sign this document and date it. Okay, do we have any questions? Okay. Yes,
What if the charges was dropped?
if the charges was dropped, you wouldn't be here. Everybody that's here have charges. Yes,
So you say that you represent yourself, you're automatically admitted guilty?
if you're, no, I didn't say that.
So,
Okay, I said you have a right to represent yourself. And I said, if you represent yourself, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities related to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, this last paragraph says, you may change your mind at any time and request that an attorney be appointed to represent you. I also said that if you represent yourself, you'll have an opportunity to talk to one of the prosecutors because you are your own lawyer. Just like your lawyer can talk to them, you can talk to them to see if you can work out your case. Right? Anybody else have any other questions? Yes.
You say that you was bond and that I get the bond for me, that's when it's money, but I'm not.
No, he was bonded. He doesn't, what's his name?
What's that wrong?
I have to look on the docket sheet.
What was the question?
He said they told him he had an attorney.
Yeah, it didn't show on here.
Yeah. If you had an attorney, it would appear on the docket sheet. And, his name is Jose. Jose Morocco, the left terrier.
Yes, sir.
No, he doesn't have an attorney. Okay, anybody else? Yes. If you apply for a court-appointed attorney, you place your initials on the third line to the left of this document. You will sign it and date it. And then you look for the form that is titled Jefferson County Affidavit of Injuries. You'll fill out the first page of this document. And on the second page, you fill out the top portion that is titled Defendant's Oath, right here. And the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Anybody else? Yes.
If you want to pay your fines, see what's the fine, I'll let you do that.
That'd be, you'll be representing yourself.
Oh.
And then you'll have an opportunity to talk to the prosecutor. They can, they'll make an offer to settle your case. And if you don't, you can accept or reject the offer. If you reject the offer, no problem. You can ask for a court-appointed attorney, or you can ask the town to hire your own attorney. Okay? Anybody else? Okay. Okay, now we're gonna give you time to fill out that paperwork in a few minutes. Next, I need to inform you that as a defendant in a criminal case, you have a right. Well, you can enter a plea of these, you can enter one of three types of pleas. Okay. One, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Now, as a defendant in a criminal case, you have a right to have a trial by jury. For that young man is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the attorneys. They will listen to the arguments by the attorneys, and then they will retire to deliberate in the jury room. They can either find you not guilty or guilty. You also have a right to waive your right to have a jury trial. What that means, to waive your right to have a jury trial means that you're giving up your right to have a jury trial. You don't want to have a jury trial. Now, if you waive or give up the right to have a jury trial, you can have what is called a bench trial. And what a bench trial is a trial by judge only, where the judge will be the judge and the jury in the case. The judge will listen to all the evidence that's presented. The judge will listen to the arguments of the attorneys, and then the judge will apply the facts to the law, and then the judge will decide to find you either not guilty or guilty. Now, you can also, if you enter a plea of guilty and no contest, you can talk to the prosecutor to see if you can work out a plea bargain. Now, there are 2 types of plea agreements. You can have what is called an agreed plea bargain agreement. A plea bargain basically is a way to settle your case. Now, if you have an agreed plea bargain agreement, that means you and the state, or you and your attorney, talk to the state, to the district attorney. They made an offer, y'all worked out a settlement, and you agreeing to accept what they offer. If that happens, then it will come before, or you will come before the court with the agreement, and the judge can do one of 2 things. The judge can either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, let's say, for example, you wanted probation, the prosecutors offered you probation, they come before the judge, and the judge said, well, I'm not going to follow that plea bargain agreement, I reject it. If that happens, then you have a right to take back or withdraw your plea of guilty or no contest. You can say, well, judge, since you're not following the agreement that I made, I wanted probation, they gave me probation, you don't want to follow that, I take my plea of guilty and no contest back. So I'm not pleading guilty, no contest. You have a right to do that. Now, if the judge does follow the plea bargain agreement that you've made with the state, and let's say within 30 days, you decided that you would like to appeal your case because you think you've been wrongfully convicted or the court committed an error by convicting. Then if that happens, you want to appeal your case, you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives you permission to appeal, your case will leave this court and go right upstairs to the 9th Court of Appeals, where there are 4 justices, 4 judges there. They will review your case to see if error was committed or to see whether or not you were wrongfully convicted. They can do one of 2 things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty and the case is over. Or they can send the case back down to this court, or to this court and give you a whole new trial. Now, if they deny your appeal, well, it's still not over because you can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. You have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means you are by yourself, you represent yourself, and you're petitioning the Texas Court of Criminal Appeals to review your case. To see whether or not they should have granted your appeal, or whether or not you were wrongfully convicted or this court committed error by convicting you. They can do one of two things. They could grant or deny the pro se petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your pro se petition, then at that point, your conviction will stand. Now, the other type of plea bargain is, let's say you and the state or you and your attorney have talked to the state to try to work out a plea bargain. You wanted probation, they want jail time. You don't want that. But you still want to enter a plea of guilty or no contest. And then at that point, you want the judge to decide what the punishment will be in your case. Anywhere from probation to fine, jail time, or jail time with a fine or probation. So we call that an unagreed plea bargain. And if that happens, then the judge will decide what your punishment will be, anywhere within the punishment range. Okay, now, as a defendant in a criminal case, you also have a right to have witnesses that come to court to testify either for you or against you. That's what witnesses do. They can testify for you or against you. You also have a right to waive or give up your right to have witnesses, meaning that you don't want to call any witnesses to come to court to testify. If you waive or give up your right to call witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination, The Fifth Amendment is the Fifth Amendment of the United States Constitution and gives us the right to remain silent. I know a lot of times we might watch shows like Law and Order on television. We see a television lawyer. There's a witness on the witness stand. A television lawyer goes up to the witness to ask questions. And as soon as they ask the question, the witness say, "I take the fifth." That means I'm exercising my Fifth Amendment right against self-incrimination, remain silent. I'm not saying that. And so if you exercise your Fifth Amendment right against self-incrimination, the state, the government, the district attorney's office cannot force you to testify. If you think about it, it makes sense. And the reason why it makes sense is because the state has the burden of proof. They have to prove you guilty. You don't have to prove yourself guilty. Okay? And so if you exercise your Fifth Amendment right against self-incrimination, you have a right not to testify. Now, you can waive, which means you can waive or give up your Fifth Amendment right against self-incrimination. If you do that, then you will be testifying in your case. Okay. Now, you also have a right to have what is called discovery. Discovery means you have a right to see the evidence or have access to the evidence that the state will be using against you. You have a right to see your statements, witness statements, lab reports, police reports. You have a right to see photos, video recordings, listen to audio recordings, documents, or any type of instrument, whatever they have, you have a right to have access to that. That's called discovery. Now, you can waive your right to have discovery, which means you're giving up your right to have discovery, saying that you don't want to see the evidence. Okay? You're waiving or giving up your right to have discovery. Now, everyone that's here today, you have charges filed against you, been arrested, placed in the county jail, you bonded out of the county jail, you get out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay a bondsman percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. I say that to say this. Every day that you spent in jail can be used as credit toward your punishment. So every 1 day that you serve in jail can be used as credit toward your punishment. Now, the operative word that I used was every 1 day. So let's say, for example, you were arrested at 11:59 p.m. on last night. You was arrested and booked in. And then you booked out of jail 2 minutes later at 12:01 a.m. That's 2 minutes, but it's 2 days. So you get credit for 2 days, not 2 minutes. So they don't go by the 24 hours, it's 2 different days. All right. So let's say, for example, if you and the state have worked out an agreement, you spent 5 days in jail, and the state is offering you 5 days to serve in jail, that means you don't have to serve no time in jail. Why? Because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they're offering 7 days in jail and you spent 5 days in jail, that means you will have to serve 2 days because you already have 5 days credit. We just subtract 5 from the 7, that leaves 2. Now, every 1 day that you spend in jail also can be used as credit toward your fine and court costs. So you receive $100 credit per day for every day that you spend in jail. So if the state is offering you, let's say you spend 5 days in jail, that's $500 credit. State is offering you fine and court costs of $500, you don't have to pay it because you've already, the time that you spent in jail has already paid it off, therefore the court cost would be taxed and retired. Now, if they're offering fine and court costs of $700, you spent 5 days in jail, that means you don't have to pay $200 because you already have $500 credit. Now, you'll be required to pay the $200 on the day that the case is taken care of. Now, if you cannot pay it, no problem, because we can put you on what is called a payment plan. That is, you can pay it off in small monthly installments. Now, even if you could not pay it off in small monthly installments because you may not have the income, no problem. We can convert the fine and court costs to community service. So for every 1 hour of community service that you perform at a nonprofit organization, you will receive $12.50 credit towards your fine and court costs. So in our scenario, if you owe $200, if you work 8 hours of community service in 1 day, that's $100. So you work 2 hours, 2 days of 8 hours community service, that's $200, and you'll be satisfied your fine and court costs. All right. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. That's for individuals who have never had, you haven't been convicted before, your first time getting in trouble with the law. And so they have a program where they will dismiss your case. And you can get it wiped off your record, like it never happened. The program is called pretrial diversion. Now, in order to qualify for the program, 3 things has to happen. It has to be your first time getting in trouble with the law. And it cannot be an offense for unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with the application process. If those 3 things happen, you get in a pretrial diversion. They dismiss the case. You complete the pretrial diversion. You can get what is called an expunction, where it will be erased, deleted, or wiped off from your criminal record like it never happened. And if you're interested in that, just let us know, and we'll be happy to point you in the right direction to talk to the right people to get you into that program. Now, Jefferson County also has another program. The District Attorney's Office has another program for veterans. If you're a veteran of any one of the branches of the United States military, they have a program that is called Veterans Court. And with the Veterans Court, you get into that program, they dismiss the case. Well, you complete the program, you dismiss the case, and you can get a non-disclosure where your record is sealed to the general public. Only qualification to get in that program is just to be a veteran of any one of the branches of the United States military. All right. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office in March of 2017. The program is called the Community Safety Initiative. commonly referred to as the CSI program. And with that program, the program is designed to address the issue of what we call recidivism. Where people, recidivism just is a word that means people commit crimes over and over. And so the way we address that is through our community safety initiative. We have partnerships with local agencies. One of the agencies that we have a partnership with is called Spindletop. The Spindletop Center, they're our local mental health center in our Southeast Texas region. And what Spindletop has the expertise to address mental health needs. Now, to participate in the program, you do not have to be incompetent or insane. You can merely suffer from anxiety or depression or any other host of mental illnesses. And they have the expertise to address your mental health needs. Now, we have someone from Spindletop in the Jefferson County Sheriff Department, Deputy Powell. He's going to come, a mental health deputy is going to come here in a few minutes and tell you a little bit more about the program. But basically what Spindletop will do, they can do a private interview either in our jury room, at their facility, by telephone, whichever is convenient for you. They can also do an assessment to determine what your mental health issue may be. And they can develop a treatment plan to address your mental health issue. If you have problems with drugs and alcohol, well, Spindletop has a program that is called ATAR. ATAR is an acronym that stands for Addiction Treatment and Recovery. And our local drug and alcohol council has a program that is called OSAR, OSAR, acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. What they would do a screening, an assessment, and develop a treatment plan to address your drug and alcohol needs. If you're unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. And it stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you trained in. Now, if you have not graduated from high school, if you do not have your GED, then they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That is, we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at Law No. 2 of Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned to you, just let us know, and we'll be happy to direct you to the people that you need to talk to get you started in these programs. Now, at this time, we have our mental health deputy, Deputy Powell. He's going to come and tell you a little bit about the program that Spindletop has to offer. Deputy Powell.
How y'all doing this morning? Not good? No, I ain't. All right, my name is Deputy Powell. I'm a mental health deputy, Jefferson County Sheriff's Office. I'm actually a tax disposal services. I normally have a mental health lady here with me, but she's not here, so I'm gonna do it myself. I'm gonna try to remember what she said. Again, I am not a mental health professional or a mental health deputy. Okay, I'll give you a history on it. That 8 years ago, when a lot of your, people with mental health and, interacting with cops and people with the heart. Now we have a civilian mental health professional that we drive for partners pretty much. Together all day, we gain some of the nerves, it's a big partnership. So we ride with them, they ride with us, we make, and our job is to make sure everybody's safe. Mental health professional and the person we're seeing, this services. Okay, now. Our goal as mental health deputies and mental health professionals is number one, keep you out of jail. By providing services. All right, number two, is to keep you out of the hospitals on diversion. That's our goal. Our goal is not to, harass you and all that. Our goal is to help you be good pretty much. And the honest piece of paper, it was at the back of the top sheet. Little small sheet. Yeah, that right there, the very first page that was on that thing, that is a handout. If you're needing assistance, now this doesn't mean, all this doesn't mean that, hey, crazy and I need to, fill this out. It's not all about having a mental health problem. It's about you in the community. So if you want to fill it out, you don't have to fill it out. They're gonna be mad at you. Want to fill it out, fill it out. If you can talk to us, we'll be available to talk to you. You can see on here, there's I need help with. There's several little check boxes that you can do. We'll contact you by phone or email. Provide those resources. Again, if you want to talk to us today about a problem, we'll talk to you today. Good question. Go ahead and fill it out, give it a couple minutes, and we'll come to it.
Okay, thank you, Deputy Powell. Okay, now, ladies and gentlemen, we're gonna give you time to fill out that paperwork that you have on the clipboard. And then we're going to pick that paperwork up. If you need help with filling the paperwork out, we have our staff here in County Court at level 2, including myself, who will be happy to assist you with filling out the paperwork. Now, it's gonna take a little time for you, I guess, finish filling out the paperwork and for us to pick it up. So if you need to use the restroom, there are 2 restrooms right out in the hall. We have the men's restroom in front of County Court at level 3. And then on the opposite side of the hall, in front of 172nd District Court, we have the women's restroom. Now, you'll be allowed to use the restroom. And once you use the restroom, please come back in the courtroom. Please do not leave the courthouse. If you leave the courthouse and your name is called and you're not here to answer, then your bond will be forfeited, which means that a warrant will be issued for your arrest. You'll be arrested, placed in Jefferson County Jail. You have to bond out again, and then we'll have to go through this all over again. Okay, so this is not going to take us that long. It's going to take us a little while to get the paperwork, make sure everything is correct, and we're going to put you in 1 of 3 categories. One category is hire an attorney. Another category is you want to apply for court-appointed attorney. And then the third category is you would like to waive your right to the attorney and represent yourself. Okay? So please be mindful that we're in court, so you need to conduct yourself accordingly. Yes, you had a question?
No, that's cool.
Okay. All right, so the court is going to go into recess. If you need help with the paperwork, or if you have finished with the paperwork, just please raise your hand and we have our court personnel who'll be happy to help. Okay, she'll come out.
Breathing.
Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 25 CCCR 1566. Case is styled the state of Texas versus Calvin Tyler Jr. Mr. Tyler, would you please come forward? For the bench. You can show him where he needs to stand. Mr. Tyler, your full name is Calvin Dwayne Tyler Jr.
Mhm.
Mr. Tyler, would you please raise your right hand? Mr. Tyler, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Tyler, you may put your hand down. How are you doing, Mr. Tyler?
Doing good.
I'm doing fine, thanks for asking. Now, Mr. Tyler, I have before me a document that is titled Judge's Explanation of Rights to Defendant Without Attorney.
Yes, sir.
Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you hired John West?
Yes, sir.
Now, before you signed and initialed this document, did you read this document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
And Mr. Tyler, your case is going to be reset to give Mr. West an opportunity to send the court a letter of representation. And before you go over to the court coordinator, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
Okay. And it states, following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, now, Mr. Tyler, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail.
Yes,
Do
sir.
you understand?
Yes, sir.
Okay, please have a seat in that first chair on the wall and wait for your name to be called. Here you go. Court is in session in 2 cases. Cause numbers 25 CCCR 1574 and cause number 25 CCCR 1575. Both cases are styled the state of Texas versus Salvador Loza Jr. Mr. Loza, would you please come forward? Mr. Loza, your full name is Salvador Loza Jr.?
Yes.
Mr. Loza, would you please raise your right hand? Mr. Loza, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Loza, you may put your hand down. How are you doing, Mr. Loza?
I'm doing good. How about you?
I'm doing fine, thanks for asking. Now, Mr. Loza, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant? And are these your initials on the line that states you would like to have your case reset to hire your own attorney?
Yes.
Now, Mr. Loza, before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read?
Yes.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Loza, your case will be reset to give you an opportunity to hire an attorney. Our court coordinator will reset your case. Once she resets your case, you're free to go and you have a blessed day. Now, before she resets your case, I need to give you some bond conditions. Bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? Okay, I'm going to go over these bond conditions with you. And it says, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yeah.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
And condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes.
And condition 7 states the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. So you have to get a GPS. Do you understand that?
I know.
You have one?
Yeah. Right.
Okay. And we need to get, do you have some paperwork on that they gave you?
I haven't seen her in a while. It's been a month since I had the paper. I mean,
Oh.
yeah.
Okay.
Yeah.
Let me do this here. This Mosby. Kiara. Okay, your full name is Kiara Marquita Hightower. Ms. Hightower, would you please raise your right hand? You swear and affirm to tell the truth and nothing but the truth to help you God? Okay, you may put your hand up. How are you doing, Ms. Hightower? That's good. Ms. Hightower, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. And Ms. Hightower, do you recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled defendant. Is this your signature? Ms. Hightower, before you signed and initialed all of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Hightower, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Now, before she gives you that information, I need to give you some bond conditions. Bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? And the document states, following return of accruing information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Yes. Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Yes. And condition number 3 and condition number 4 do not apply. However, condition number 5 does apply, and it states, defendant is prohibited from possessing firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Ms. Hightower, do you understand that condition? Yes. Ms. Hightower, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You will be arrested and placed in the Jefferson County Jail. Ms. Hightower, please have a seat in that first chair. Yes.
I will have to wait till after my case is closed to be able to get my firearm.
Well, you can talk to your attorney about that. Okay. Just have a seat in that first chair. Janai Monique Charles. Ms. Charles, your full name is Janai Monique Charles?
Yes, sir.
Ms. Charles, would you please raise your right hand? Ms. Charles, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Ms. Charles, you may put your hand down. How are you doing, Ms. Charles?
I'm fine.
I'm doing fine, thanks for asking. Ms. Charles, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
Ms. Charles, I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Sir.
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Ms. Charles, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Charles, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Taylor Smith. How do you pronounce your middle name? Ariane? Okay. Miss Smith, Taylor Ariane Smith. Miss Smith, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now, Miss Smith, you may put your hand down. How are you doing, Miss Smith? Good. Now, Miss Smith, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant. Signature. Is this your signature? Now, Ms. Smith. Before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes.
Okay, Ms. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Now, Ms. Smith, I see that you're not here long. Okay, who do you have? Who is here with you? Your mom? Okay. Now, Ms. Smith, I know that you're a young lady, and a lot of young people put a lot of stock in their friends. I think you say that's my BFF or that's my ride or die. You always say that those are the people that will be with us through thick and thin. In my day, we used to say that was my ace boon coon. But on days like today, when you need a friend, those people that you normally call your ride or die or your BFF, your best friends for life, they're not here. And the reason why they're not here because they have something else to do. They figure, they have more important things to do than to be down here with you. But your mom, who's here, she had other things to do too. But she felt that there was nothing more important than to be here with you this morning, right? I tell people this all the time. Everybody's not your friend. Everybody's not your partner. But when that lady says she got you, she got you. Okay? And so, she's the person that probably put a roof over your head, clothes on your back, food on the table, And every now and then, I know while you was growing up, she probably put a little spanking on your butt. And she did all of those things because she loved you. And she's here today because she loved you, okay? Now, I know this is not the best day of her life to see you here before the court, before a judge. And you might think that you're in a storm, but just remember this. When you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. And so there's one thing about hope, hope floats. Okay, so when you're drowning in a sea of confusion, just remember to hold on to that hope. And what I'm trying to get you to understand is that whatever happens in this court, this is not the end all. Okay, this is not the destination. Okay, you know, your current situation is not your destination. Okay, you still can accomplish anything that you want to accomplish in life. Okay, but you just have to hold on. And you know, a lot of times people might say, you know, well, this is a stumbling block, but you can look at it as a stepping stone. And people use stepping stone to reach higher heights. Okay, and so before the day is over, you probably need to get that lady that came down here that you call mom a big hug and a kiss. Okay, because everybody's not blessed like you to have a mom or a parent or someone to come down here and support them. Ma'am, thanks for coming down here with your daughter. Stay, you know, I tell people this all the time. Just hang on, don't hang up. All right, just stay with her. All right. So you're gonna get your case reset. Once you get your case reset, you'll be free to go and you have a blessed day. Okay, you have a blessed day too, man. Yes, I got Owens. Oh, yeah, but I think the other guy, his is just a reset. Roy Lynn Owens, make, we probably can get Jennifer to be on the way. Okay, Mr. Owens, would you please raise your right hand? Mr. Owens, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Owens, you may put your hand down. How are you doing, Mr. Owens?
I'm doing fine, and you?
I'm doing fine. Thanks for asking. Now, Mr. Owens, I have two documents here. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
And are these your initials on the line that
Yes.
state you would like to waive your right to attorney represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. Do you recognize this document?
yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Owens, before,
Printed on now. She wrote it on this. It didn't say signature. It
okay,
said name, so I just printed it, and then that's my signature.
okay, well, that's fine. Now, Mr. Owens, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Now, Mr. Owens, I understand that you have talked to the prosecutor, Ms. Haley Simmons,
yes, ma'am.
and you will be meeting with her on tomorrow. Is that correct?
Yes, Your Honor.
Yes, sir.
All right. So what we're going to do is reset your case, give you time to meet with Ms. Simmons, and we're going to put him on a just a regular announcement docket. Okay. All right. So you stay, have a seat in that first chair and wait for your name to be called.
Thank you.
You are. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 1680. Case is style of state of Texas versus Jose Barranco Galatria. Mr. Barranco Galatria is present in court. He speaks Spanish, some English. We have Miss Jennifer Raji, who is our interpreter. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear or affirm to interpret Spanish to English and English to Spanish, so help you God?
Yes, Judge.
Mr. Raji, you may put your hand down. How are you doing, Mr. Raji?
Good, Judge. Thank you for asking. And you?
I'm doing fine. Thank you for asking. Now, Mr. Raji, please ask Mr. Jose Barranco Galatria if his full name is Jose Barranco Galatria.
Su nombre completo es José Barranca Galo Río.
Es José Guadalupe Barranco Galata.
José Guadalupe Barranco Galata.
Okay. How you doing, Mr. Barranco Galatria? Ask him how he's doing. You doing good? Okay. Ask him to raise his right hand. Okay. Mr. Barranco Galatria, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yeah, tell him he could put his hand down. Okay. Now, state is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
Okay. Miss Araji, you can inform Mr. Barranco Galatria that he has a right to have a court reporter to be present and type everything, or he also have a right to waive or give up his right to have a court reporter. Ask him if he waive and give up his right to have a court reporter.
Okay, es para que no se le va a hacer para tener una símbolo para el repertorio. No. He said he's gonna give up the right.
He giving up the right? Okay.
Yes.
Now, Mr. Barranco Galatria, I have before me a document on my computer that's titled information. In this information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jose Barranco Galatria, on or about June 1st of 2025, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Do you understand what you have been charged with?
Yes.
To this charge, how do you plead? Not guilty, guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Barranco Galatria, I have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there are 2 sets of initials. The first set of initials are on a line next to a box that says check nolo contendere, which means no contest. Would you place your initials on this document?
Yes.
The second set of initials are on a line that is titled, that states rather, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Are these your initials?
Justicia sustancial para la información para el abogado para. Yes.
And I'm gonna go back to page 1. On page 1, at the bottom, the second to the last paragraph is titled Citizenship. And it states, if you are not a if you're not a U.S. citizen on a plea of guilty and nolo contendere, it may result in your deportation, exclusion from admission to the country, or denial of natural law or denial of citizenship. Do you understand that?
Yes, Judge.
Okay, I'm gonna do that again. It says that if you're not a citizen, a plea of guilty and nolo contendere may result in your deportation, exclusion from admission to the country, or denial of citizenship, denial of naturalization under federal law. Do you understand that?
Yes. Judge.
And you place your initials below that paragraph, signifying that you understand what it means. Is that correct?
Sí, pues esos iniciales ahí diciendo que entendiste lo que te leí.
Sí.
Yes, Judge.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
¿Esa es su firma ahí?
Sí.
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
¿Después ese documento? Yes.
Is this your signature on the line that's titled defendant?
Yes, es su firma. Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Dice que ahí arriba está sellado 2 cajas. La primera caja dice que no se puede hablar en este caso, que sí entiende Sosa. Yes.
And the second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Esa caja dice que está dejando que su voluntad para este caso, que sí entiende. Yes.
Sign that one in this. I also have a document that is titled English Statement for All Foreign Nationals Except Those from Mandatory Notification Country. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Is it super mine? Yes.
There's one word that's circled and the word is no, and it is below a question. And the question is, do you want us to notify your consular officers at this time? And you circle no, is that correct?
Y pusiste que no quieres que el cuerpo notificara su consulado de su país, ¿verdad? Sí. Bueno.
Now, Mr. Jose Barranco Galatria, I also have 2 more documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
¿Te acuerdas ese documento? Yes.
Is this your signature on the line that's titled defendant?
¿Es esta firma ahí? Yes.
And are these your initials on the line that state you waive your right to an attorney and you would like to represent yourself?
Y pusiste sus iniciales diciendo que estás dejando que su derecha para un abogado y no quieres hacer un caso solo. Yes.
Also, have a document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
¿Recuerdas este documento?
Sí.
Yes.
Uh, Is this your signature online as titled defendant?
¿Y esa es su firma ahí?
Sí.
Yes.
Mr. Barranco. Barranco. Before you sign and initial all of these documents, did Ms. Araji go over these documents with you in Spanish?
Antes de firmar todos esos documentos, sí te explico todo en español antes de firmar.
Sí.
Yes.
And did you understand everything that Ms. Araji went over?
¿Y usted entendió todo que te expliqué antes de firmar?
Sí.
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Todo está en los documentos que firmé, ¿es verdad?
State.
State offer States Exhibit 1.
Mr. Barranco Galatria. The state is offering states exhibit number 1.
El abogado está.
And they offer states exhibit number 1 to be used as evidence against you. States exhibit number 1 is this first document that I showed you on the tablet.
Esa es la definición bien tengo a usted.
This is the same document that have your initials in these 2 locations on page 2.
Es la que tiene sus iniciales ahí apuntado.
And it has your signature on page 3.
Y también tiene su firma ahí en página 3.
Is it all right for the state to use this document as evidence in your case?
Y está bien que se use esa información. Yes.
Okay, no objections. State's exhibit number 1 will be admitted. Mr. Barranco Galatria, is there any evidence that you are currently mentally incompetent to stand trial?
Está preguntando pues si no tiene ninguna cosa voluntad. No, que no se puede hacer su caso. No. No.
No? Okay. Mr. Barranco Galatria, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt.
Y que todo tiene suficiente para que no.
State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 180 days county jail, probated for a period of 15 months of community supervision, fine of $750, repayment of court costs, 60 hours of community service, requirement of the interlock device, and the standard terms and conditions for a DWI first.
What's the court cost? Okay. Mr. Barranco Galatria. The state is offering that you serve 180 days in the Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months.
Que está bien, 180 días bien encerrado, pero no vas a tener que estar encerrado porque está dando 15 meses de probation.
You will also be required to pay a fine of $750, court costs of $392, a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month. For your analysis fee of $15 a month. A reimbursement fee of $15. You will also be required to pay Jefferson County DWI initial evaluation fee of $125.
Y también se pagan 125 de examinación.
Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is, the total amount that you will be required to pay each month, is $170 a month. Will you be able to pay the $170 each month?
Por los 15 meses a $670 cada mes para los 15 meses. Está preguntando si usted se lo puede pagar eso para los 15 meses.
No se podría un poquito menos.
Así son los pagos.
Ok, está bien.
170.
Por mes. Por mes. Está bien.
Yes.
Okay. You'll also be required to perform 60 hours of community service.
Servicio de comunidad, $60.
Install an interlock device on any vehicle that you own or operate. Attend and complete a DWI class. Have an alcohol assessment and adhere to the other standard terms and conditions of DWI probation.
Y completar todo lo que necesite provisión.
Do you understand the state's offer?
Yes.
Do you think the state's offer is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Okay, I'll follow the plea bargaining agreement that you have entered into with the state. Please stand in front of stand next to the bailiff and follow her directions. Okay, once you finish following her directions, you're free to go and you have a blessed day. Okay, and you have a blessed day. Okay, you're welcome. And you have a blessed day as well, Mr. Rogers.
Thank you, Judge.
Okay. Okay. Okay, Jeremiah Fobbs. That was an out of county bond. You know if they got notice? I did, okay. This is cause number 25 CCCR 1370. Case is filed the state of Texas versus Jeremiah D. Fobbs. Ms. Fobbs, well, Mr. Fobbs was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of Jeremiah Fobbs at the courthouse door. Mr. Fobbs did not answer. Mr. Fobbs has not appeared in court since the court has been in session. The time now is 11:39 AM on today's date of September 2nd of 2025. Ms. Bailiff, would you please call the name of Jeremiah Fobbs at the courthouse door?
Jeremiah Ball. Jeremiah Ball.
Okay, Jeremiah Fobbs' name was just called again at the courthouse door. Jeremiah Fobbs did not answer. A reasonable time has passed to give Mr. Fobbs an opportunity to appear in court. It's not appearing in court. State, do you have a motion? That motion will be granted. Jeremiah Fobbs' bond will be forfeited and a warrant shall be issued for his arrest. Next case is cause number 25CCCR 1590. Case is style the state of Texas versus Jarretts Alejandra Ramon. Jarretts Ramon was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of Jarretts Ramon at the courthouse door. Jarretts Ramon did not answer. The time now is 11:41 AM on today's date of September 2nd of 2025. Ms. Bailiff, would you please call the name of Jarretts Ramon at the courthouse door?
Direct Ramon. George Franchard.
Jarretts Ramon name was just called again at the courthouse door. He did not answer. A reasonable time has passed to give Mr. Ramon an opportunity to appear in court. Is not appearing in court. State, do you have a motion?
State with your bond forfeiture.
That motion will be granted. Jarretts Ramon bond will be forfeited in cause number 25CCCR 1590. Next case is cause number 25CCCR 1558. Case of style of state of Texas versus Calvin Thomas Jr. Calvin Thomas Jr. was scheduled to be in court at 9 AM. At about 9 AM, the court's bailiff called the name of Calvin Thomas Jr. at the courthouse door. Calvin Thomas Jr. did not answer. He has not appeared in court since the court has been in session. The time now is 11:42 AM on today's date of September 2nd of 2025. Ms. Bailiff, would you please call the name of Calvin Thomas Jr. at the courthouse door?
We had two new houses from family side, and I know one.
How about somebody on the phone? Name is Calvin Thomas Jr.
Calvin Thomas Jr. Calvin Thomas Jr. George Franchard.
Okay, Calvin Thomas Jr. name was just called at the courthouse door. Calvin Thomas Jr. did not answer. Reasonable time has passed to give Mr. Thomas an opportunity to appear in court. Is not appearing in court. State, do you have a motion?
State with your bond forfeiture.
That motion will be granted. Calvin Thomas Jr. bond will be forfeited and a warrant shall be issued for his arrest. In cause number 25CCCR 1558. And this will conclude the calling of the court's arraignment docket on today's date, September 2nd, 2025, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. State prosecutors, you are excused.